Welcome to Graphic Online TV. Today being the Constitution Day, we are here to interview the Honorable Attorney General and Minister of Justice, as well as the Principal Legal Advisor to the government, Honorable Godfrey Yeboah-Dame. Our discussion will detail on various aspects of the Constitution, whether there's a need for constitutional reform or whether there's a need for overhaul of the whole Constitution. Yeah, thank you. Honorable, thank you very much and welcome to Graphic Online TV.
Welcome to my office. Happy New Year.
Many happy returns, Honorable. Since our Constitution came into existence, that's almost about 31 years now.
Right.
And it has served us throughout this whole Fourth Republic. We have been about 5 successive governments and
right.
We are still going on. But there has been many calls for constitutional review. Advocates like the Honorable Majority Leader, Minority Leader have called for review on the cap of the number of ministers. Others have called for a review to more or less limit the powers of the president. Others who have different views. The eminent Professor S.K.B. Asante is of the view that we don't need to change the text of the Constitution. What we need is attitudinal change and the values in it. Honorable, what are your views? Do you think this Constitution has served us well, and do we need to review it? And if we have to review it, where should we review?
Apart from the Declaration of Independence, the set of rules by which any nation is governed is actually the most important document the nation can enact for itself. The set of rules will set out institutions that will carry out the objectives of the nation, the right, inalienable right to the citizens, the limits of those rights, the interaction between the powers of the state and the rights of citizens and whatever. So for me, and all those rules clearly will be embodied in what we call the Constitution. So the Constitution is the most important document in the nation. And I think the question as to whether the Constitution has served the nation well or not ought to be examined in light of the international standards for a Constitution. Now, internationally, a Constitution is required to set out for the people principles of democratic governance. Okay. And I think in my respectful view, this Constitution has lived up to the international standard of setting out for the nation a sound democratic order and the principles of the tenets of constitutionalism. Yes, it has become fashionable for people to talk about a review of the Constitution. Some even go as far as suggesting that there ought to be an overhaul of the Constitution. Well, I think that there ought to be an assessment of the benefits of the Constitution periodically. And that is why I welcome the institution of the Constitution Day, because it provides for us an annual opportunity for us to reflect on the Constitution, the benefits of the Constitution, the lapses of the Constitution, and how far as people we can go to strengthen the Constitution. But I think in terms of the international standards that are required for a Constitution or the international prescription for a sound democratic order, this Constitution clearly satisfies the standard. Now, we must take account of where we are coming from as a nation. The Constitution is a product of constant but peaceful evolution of the people of Ghana. Indeed, the genesis of it is traced to the report to the Committee of Experts presented the PNC government in 1991 for the promulgation of a constitution. Now, that report to the Committee of Experts became the subject matter of huge deliberation and consideration by the Constitutive Assembly. So the final report to the Constitutive Assembly, which of course was subjected to vote at a referendum in 1991, and which the people voted for in 1992, voted for, is actually not what led to the Constitution. It is the original report of the Committee of Experts. And that Committee of Experts was chaired by the gentleman that you mentioned, a very good citizen of Ghana, in fact, a massive brain in constitutional law and generally all matters of law in the country, Nana Dr. S.K.B. Asante. And I share his view that in terms of the assurance of tenets of constitutionalism for this nation, this constitution satisfies the standard. So, a committee of experts took account of certain standards and principles. And the principles, first and foremost, are as recognized internationally. The first principle is the election of an executive president directly by the people. And you see that this constitution even presents for the people of Ghana a better option than the Constitution of the United States of America, which is recognized to be the largest democracy in the world. In America, yes, even though there's election by the people, the final determination is actually the electoral college, and that is not democratic. We've had instances where the winner of the popular vote necessarily did not become president, and that's clearly undemocratic. In Ghana, you have a firm assurance situation where the executive president is directly elected by the people of Ghana. And there's also a federal requirement that even if the first election did not produce a winner who attained more than 50%, then there ought to be a federal recourse to a second election to ensure that the ultimate winner garners a broad support to the people. Then there's also the election of the legislature directly by the people on the basis of universal adult suffrage. Another important pillar of the Constitution, which we sometimes tend to underrate, is the establishment of a free, independent judiciary. A judiciary which is vested with the full powers of judicial review. And our judicial review is remarkably set out in the Constitution itself. Unlike America, where the Constitution itself does not give to them the power of judicial review, but the U.S. Supreme Court had to have recourse to a process of constitutional interpretation in order to assume that power of judicial review. Now, again, our judicial review, exercised by the Supreme Court of Ghana, is better in every regard than the concept of judicial review in the United Kingdom, where the United Kingdom Supreme Court may pronounce on the consistency of legislation in the UK with a European Convention, but does not have the power to pronounce on the legitimacy or lawfulness of an act of parliament by virtue of the concept of parliamentary supremacy. So you see, this constitution jettisoned the concept of parliamentary supremacy and made the constitution itself the supreme authority. Every person, every authority in the country, president, parliament, and all, are subject to the constitution. Then our judicial review, again, is also better than situations in Central and Eastern Europe, whereby the exercise of judicial review by the Supreme Court can be overridden by a specific or prescribed majority of the legislature. So there's no way a Parliament of Ghana can pass a law overriding or prescribing the exercise of any judicial review function by the Supreme Court. And that's a very important thing. Recently, we woke up to the news of the Parliament of Israel, the Knesset, enacting or approving of the passage of a bill to abolish the powers of the Israeli Supreme Court in judicial review. The Supreme Court had to assert itself again on 1st of January 2024 and say that notwithstanding that law, they still have the power. We cannot find such a situation at all in Ghana. Again, the other principle of the Constitution is the establishment of a healthy system of decentralization, which is prescribed to be non-partisan, and which results in the election of these assemblies and whatever. Of course, some may take the view that there's a need for us to reform that system, and I also subscribe to that view, that ultimately we have to reform the assembly system. But at least there's the establishment of the concept of decentralization in the Constitution. Another important element of our Constitution is the enactment of a comprehensive Bill of Rights in Chapter 5 of the Constitution. Indeed, one American constitutional scholar remarked to me when he visited Ghana that in Ghana we seem to have more rights set in law than in America. The American Constitution, which is started as the oldest constitution in the world and the most resilient, as well as the one practiced by the largest democracy, originally was only or had only 6 broad articles, over 4 pages. That's the Constitution. So clearly there was no provision for a comprehensive Bill of Rights. And it's actually the process of constitutional interpretation, of course, enactment of laws that have resulted in American citizens being accorded rights. In our Constitution, right from the outset, or right from the inception, there is the assurance of this Bill of Rights. And no, it goes beyond. And I think the reason why it's so broad is also an account to the fact that Ghana had, before 1982, subscribed to a number of UN conventions. In 1991, we subscribed to the UN Convention affecting the rights of children and all, and also the rights of women and all. So all these have become part of it. And the Constitution Article 33, Clause 6 actually specifies that the Bill of Rights in Chapter 5 is not even exhaustive. There's opportunity to take account of other rights as may over time become permissible or acceptable in any healthy democracy. So I look at it and see that really our Constitution is quite strong in terms of the establishment of institutions to guide the people and to deliver to the people a sound social economic life, if only the people of Ghana will apply the Constitution in its true letter and spirit. You look at Chapter 6 of the Constitution, Directive Principles of State Policy, which ensures that the nation is supposed to be developed in a very balanced and equal manner. I mean, this is quite novel for the Constitution of a country to prescribe that in terms of distribution and allocation of resources and all, it ought to be done in a balanced and equal manner. So indeed, I share the view that rather than overhauling the Constitution, there's a need for us to strengthen the institutions, strengthen the capacity of the institutions to hold government accountable and to ensure that the right thing is being done. It's actually the human element, the people can also not be overlooked. So the human element in terms of appointment of right personnel who would ensure that the objectives of the Constitution are met is very, very important.
Some of those who are advocating for, if not a total overhaul, but a substantive amendment of the Constitution, they talk about the fact that Parliament is supposed to be independent. You have majority of your ministers. Who are they going to owe allegiance? Is it to Parliament? Is it to the executive? That is one. Others also have problem about what they call the unvested powers of the president. For instance, the president has power to appoint so many people. What are your views on that in terms of the amendments? Yeah.
Right. Now, I'll deal with the specific issue. But I think it's also important for me to underscore the fact that part of the processes for control of executive power is the broad array of powers conferred on Parliament. Yeah. So indeed, right from the participation of Parliament in the approval process of a minister in Article 78, Clause 1, to other matters relating to approval of international treaties and obligations, agreements, and what have you. Parliament exercises the power to scrutinize executive action. So the president is compelled to subject the approval of his ministers to parliamentary, or the appointment of his ministers to parliamentary approval, Article 78, Clause 1. Parliament has a role in checking whether indeed the right caliber of personnel are being called up into the executive. Parliament also has the power to approve financial estimates of the government in Article 179. Parliament also has the power to impose or grant taxes. So the power to impose taxes on the people is actually exercised by Parliament in Article 174 of the Constitution. Parliament is also required to approve every loan, international business or economic agreement, again in Article 181, Clause 5 of the Constitution. Apart from that, Article 75 of the Constitution also vests Parliament with the power to approve any international treaty or agreement entered into by the executive. So you see that again, Parliament has the power to appoint an auditor to audit the Auditor General in Article 187, Clause 15 of the Constitution. So you see that in terms of any major decision which will affect the national purse, the economic purse, the lives of the people, how the nation is supposed to be governed, the nation's international obligations or treaties and all, Parliament has a direct power. And the Parliament is again vested with power under Article 103 of the Constitution to conduct an inquiry into any activity of a ministry, department, or agency of the country. And we have seen the exercise of such a power recently, where Parliament has set up a committee and all. Parliament has the power to conduct such a probe. So I think we must understand this one and see how the broad architecture of the Constitution itself acts as a check on the executive. Now, I will say that clearly, I mean, any document enacted by people, which is supposed to serve the people, will have to be subjected to review as time goes on. I've already made a point that that's why there's a need for us to have this constitution review. But of course, but I would also say that indeed the fashion whereby people on a daily basis, weekly basis, a monthly basis hold seminars asking for review of the constitution, for me itself is antithetical to the constitution. It undermines a sound democratic order. Indeed, when I was Deputy Attorney General, recognizing that there's a need for constitutional reform, the then Attorney General set up a committee, which was chaired by my good self in 2018. The committee was made up of representatives from even civil society and members of government. The members of government were myself, my colleague Deputy Attorney General Joseph Ekpenka, Obiamwa, Deputy Minister for Local Government at that time, Professor H. Kwesi Pempe of the CDD, the late Akoto Ampao, and all, and we invited even proposals from Institute of Democratic Governance and all. The call for an overhaul of the Constitution is, with all respect, a little bit improper, and that there ought to be an assessment of very key provisions of the Constitution which required urgent reform. One of the provisions that we held to be unhealthy for a proper working of the Constitution was Article 70, Clause 1 of the Constitution, because we felt that clearly it undermined the principle of separation of powers, and that the requirement for the President to appoint a majority of his ministers from Parliament was unnecessary. The President may, if he deemed fit, appoint such majority from Parliament, but it ought not to be a requirement of the President to appoint a majority of his ministers from Parliament. The President should be given a free hand, so the President can appoint 10% of his ministers from Parliament, 15%, 45%, 65%, and whatever. So we recommended to the Attorney General that there ought to be at the appropriate time the tabling of a bill in Parliament for the amendment of that provision. But of course, we recognize that that's an entrenched provision. It's a bit an entrenched provision. It will have to go through the laborious process of first being introduced in Parliament, referred to the Council of State, and then referred to the Electoral Commission again for a referendum to be conducted and all that. So that's very elaborate. So I also take the view, and which was actually contained also or reflected in the report of the committee that I indicated, that the process for appointment of officers specified under Article 70 ought to be strengthened through the participation of Parliament. So you find various officers of state who are appointed without parliamentary approval, and I find it very improper. So you find Auditor General, Commissioner of Human Rights, Administrative Justice, the Commissioner of Civic Education, the Electoral Commissioner, and all that. I think all those, the whole gamut of officers listed in Article 70, for me, ought to be approved by Parliament as well. So there ought to be the introduction of parliamentary approval into the appointment process. And that was contained in a report that we presented to the Attorney General in 2019. Then we also found that the process for approval of subsidiary legislation ought to be strengthened. So in this situation, there's virtually no participation at all by Parliament. Once a subsidiary legislation is laid in Parliament, it automatically becomes law until it is annulled by the votes of no less than of 2/3 of Parliament. I think we took the view that it ought to come into force after the lapse of 21 days after being introduced on the order paper, and Parliament has, by the vote of a simple majority, approved of such legislation. That for us will ensure that there's opportunity for subsidiary legislation to be fine-tuned and all, rather than giving this or allowing this situation to prevail where the legislation becomes law after being introduced in Parliament, and if it is not annulled by the vote of less than 2/3 of Parliament. We also take the view that if you look at Article 60 of the Constitution, there's no direct provision on how a vacancy occurred or created by either the death or resignation of a vice president ought to be filled. And that was a very big lacuna in the Constitution. So there ought to be an amendment of Article 60 to ensure that the successor to the vice president, when the vice president either resigns or in the unfortunate circumstance where he passes, yes, a vacancy is created. So Parliament, the president ought to be able to appoint a new vice president within 14 days, of course, with parliamentary approval after the vacancy has occurred. And also, if we look at Article 60, we also took the view that it is incongruous for the president to be held to be unable to perform his functions when he's outside the country. So the president is at the United Nations performing his functions, representing the nation. How reasonable can it be that he's unable to perform his functions? Indeed, he's performing his functions there. So our view is that there ought to be an amendment in order to ensure that a person swears the oath to act as president only when the president is unable to perform his functions, other than situations where absence is construed to be inability to perform functions. I think it's most unhealthy.
Two follow-up questions. So what has become of this your recommendation?
Yes, so the recommendation we actually acted upon. One major recommendation we made was for reform of the decentralization process. And we recommended that these assemblies ought to be elected. And of course, there ought to be a further amendment of Article 55 to ensure political party participation in the process. And that was instructively pursuant to a paper presented by IDEC, Institute of Democratic Governance, Dr. Akwete. And we agreed with that proposal that indeed there ought to be. And indeed, the process was started. So our ultimate recommendation to the Attorney General in 2019 was that the process of presenting to Parliament or for the consideration of the people few provisions of the Constitution which required urgent reform ought to be done gradually. So the first step was to deal with the decentralization process, which we presented, and of course a bill to that effect was presented to Parliament. Unfortunately, we know what happened. It had to be withdrawn. The process had to be curtailed because of the opposition from largely the other side of the political divide. And I think it's something that eventually can look at.
Honorable, you chaired a committee that made very substantial recommendation on various aspects on constitutional review. But before your committee, there was a larger committee, or let me say there was another committee, which also made equally substantial recommendation. We didn't see the light of day, or that their recommendation didn't see the light of day. So my question is that, what was wrong with Professor Fiajo committee's report that we had to more or less set up another committee to virtually do the same thing that they did? Why couldn't we work with the Professor Fiajo committee? And flowing from that same question, currently Parliament also has another committee which is also working on constitutional review, and it's also saying that it will be reviewing part of the Professor Fiajo's committee's report and all that. So it looks like is it a case that we are implementing recommendations?
That is why I made the point that it's become fashionable for people to talk about constitutional review and to on almost a weekly or monthly basis hold seminars and platforms for review of the Constitution. Now, the Constitution Review Commission exercise was actually a very important exercise that was undertaken. I don't know whether it is that one or the Implementation Review Committee, which was chaired by Professor Fiajo.
So both of them, because they are
no. So there was first a Constitutional Review Commission, which came up with a gamut of provisions.
Chaired by Professor E.O. Dankwa, I think so.
Precisely. Gamut of provisions to be amended. Then there was a Constitution Review Implementation Committee set up by the Mills Mahama administration, I think President Mahama, to work out modalities for an implementation of the earlier report by the Constitution Review Commission. And that Constitution Review Implementation Committee came up with two major bills for the amendment to the Constitution. One bill was an amendment of what was described as the entrenched provisions, and that bill was an amendment of non-entrenched provisions. But the absurdity was this: the one bill for the amendment of entrenched provisions contained proposals for amendment of as many as 40 provisions of the Constitution. So all the entrenched provisions of the Constitution which had been recommended in the Constitution Review Commission's original report culminated in the enactment of one bill for the amendment of all the provisions. And those provisions included provisions relating to the repeal of the death penalty, amendment of Article 70, Clause 1 of the Constitution, maybe asset declaration and all that. So totally unrelated provisions. So recognize how indeed forced the process was. And so our committee, in trying to examine how to implement that report, came to the conclusion that it was actually, with all respect, improper for the people of the nation to be allowed to vote on one bill which contained amendment of 40 provisions of the Constitution, which are unrelated. So at a referendum, the question will be, do you agree to the bill, yes or no? But if you say yes, you may be saying yes to a repeal of death penalty, but not necessarily another provision, Article 70, Clause 1. And that was it. So clearly it was impractical. So the report of the Constitution Review Implementation Committee, which resulted in the enactment of two bills for amendment to the Constitution, clearly was outmoded at best, and people even found it to be a little bit fraudulent. It's a fraud on the people, because clearly people will be misled in making a choice, and was impractical. So that has to be, with all respect, jettisoned. And the same also held for the amendment of the non-entrenched provisions. One bill for amendment of about 50 or 60 unrelated non-entrenched provisions. So that's why the committee, which comprise people like H. Kwesi Pempe, Sakutampa, the late Sakutampa, myself, and Obiamano, indicated that there's a need for us to prioritize key provisions in the bill which required urgent reform. And we came to the conclusion that we needed to amend about 9 or so provisions of the Constitution. And one of them was a provision on the decentralization process, which of course we took steps on by presenting the bill for consideration by the people, and which ultimately, as we all know, was rejected. The process had to be withdrawn, curtailed, whereby we're going to amend the provisions in Article 243 and 55 of the Constitution. So that's why I take the view that rather than an overhaul of the Constitution, there's a need for us to practically examine the value of the Constitution. And when that is done, we'll come to a firm conclusion that indeed our Constitution assures the nation the tenets of a sound democratic or constitutional order. It talks about an executive elected directly by the people, executive president elected directly by the people, the Parliament of Ghana elected directly by the people, which also has powers to control exercise of executive power from the appointment of personnel into the executive and the judiciary. In Article 144 of the Constitution, the Supreme Court nominees are all subjected to parliamentary approval. Indeed, if Parliament were to be exercising its powers stringently and appropriately, of course, we also talk about the approval of the budget of financial estimates of the government in Article 179 of the Constitution. We talk about the power of Parliament to impose or vary taxation in Article 174 of the Constitution. We talk about the approval of international agreements and treaties entered into by the President under Article 75 of the Constitution, as well as Article 181 of the Constitution, which also requires Parliament to approve every loan, international business or economic agreement. So, and I think that also key, as I indicated earlier on, is the Supreme Court's power of judicial review. And another area that I think we also perhaps need reform is amendment of the constitutional provisions relating to the judiciary itself. And the fact that under Article 131 of the Constitution, every appeal, an appeal shall lie as of right to the Supreme Court from a decision of the Court of Appeal in a civil or criminal matter, where the case emanating from the High Court. It's wrong. It's something that overburdens the Supreme Court. I think that there ought to be a reform of the Constitution to ensure that the Court for Appeal becomes the final appellate court in most matters. Because indeed, we must take account to the fact that our Supreme Court, unlike the American Supreme Court, is also an appellate court in chieftaincy matters, also exercises supervisory jurisdiction, is also an election petition court, and also has powers of review. So if you see the multiplicity of jurisdictions exercised by the Supreme Court, clearly it will indicate that the composition of the Supreme Court as specified in the Constitution will have to be enhanced. And I think that the Supreme Court itself also perhaps has to be more proactive and circumscribe its own jurisdiction by assuming certain cases reluctantly. And of course, this is something that can be done by legislative reform. But I think to start with, there must actually be an amendment of the Constitution to ensure that the various jurisdictions of the court is actually spelled out by law and regulated by law as and when circumstances become necessary. Because really, it's only in Ghana that you find a Supreme Court jurisdiction or the jurisdiction of other courts, including the High Court and whatever in the Constitution itself.
And that ties in with the question of should we have a ceiling to the number of justices appointed in the Supreme Court?
Well, I've already illustrated that if you look at the multiplicity of jurisdictions in the Constitution, that question will have to be answered quite slowly. I mean, we have to be quite careful in putting a ceiling on the Supreme Court, because it is not like the American Supreme Court, which sits only on specific cases which are in the public interest. In this case, there's an appeal as of right from every decision of the Court for Appeal, a matter where it emanates from the High Court. And even if it is below the High Court, emanating from an inferior court, either the Court for Appeal or the Supreme Court itself can grant leave. And so really, the Supreme Court is inundated with all manner of cases and all. And I think that we have to first refine the jurisdiction of the court before we even contemplate placing a ceiling on the Supreme Court.
For more news, please visit our website graphic.com.gh or follow us on Facebook at Daily Graphic and on YouTube and Twitter at GraphicGH.
Subscribe now.